Legal Ombudsman, P.O. Box 6806. Wolverhampton, WV1 9WJ. T0300 555 www.legalombudsman.org.uk. Private and confidential. Mr. S. Hussain, 20 Primary Way, Bradford. BD2 4RT. July 24th, 2023. File reference F136552. Dear Mr. Hussain, your complaint about Burke Miazzi Limited. I am writing to you about your service complaints about the above firm. My colleague, Sion Jeffries, wrote to you on May 16, 2023, and gave notice she intended to ask an ombudsman to dismiss your complaint for the reasons stated in her letter. I would explain, I have now been asked to consider whether your complaint should be dismissed under 5.7 of our scheme rules. I will not be undertaking an investigation into the service provided by the firm or other agencies. Neither will I be considering the issues you have raised about the service this organization has provided, which is addressed under a separate process. Rule 5.7 states an ombudsman has discretion on whether a complaint should be dismissed dependent upon the circumstances of an individual case. A request has been made to dismiss your complaint on the grounds that it does not have any reasonable prospects of success or is frivolous or vexatious. Legal Ombudsman. And there are other compelling reasons why it is inappropriate for the issue to be dealt with by the Legal Ombudsman. I would explain that the case has been referred to me for a decision on whether the complaint has any reasonable prospects of success at investigation. I confirm that the issues raised with the firm are not considered either frivolous or vexatious. I would take this opportunity to acknowledge that the events in relation to the removal of your mother from your care at home have been especially distressing. I understand from the correspondence that your mother passed away in care, and this has caused you and your family considerable distress. I would express my sincere condolences for your loss. From my review of the file, I note that the firm were instructed by you in a litigation matter seeking to appeal orders made in court of protection proceedings concerning the care of your mother and the injunction proceedings. I appreciate that the outcome of the appeal proceedings and order made on October 1st, 2021 by the Court of Appeal is not the outcome you were seeking. I have been provided with a copy of the order in which the court have made clear findings in relation to the grounds of appeal. I cannot agree with your assertion that the outcome of the proceedings would have changed had the firm not sought a capacity assessment in relation to you. The reason for this comment is I note that following the capacity assessment, the court appointed you a litigation friend. It was therefore agreed with the assessment, and the court considered that you required support in the litigation proceedings. My role does not include a determination of either issues of capacity or legal matters, but I am persuaded by the findings of the court which support the advice and actions of the firm in their conduct of your case. From my review of the file, I have seen that you have raised a number of complaints with the firm in telephone calls and emails, to which they responded. On file, we have copies of the complaint correspondence, which I have reviewed and considered prior to the making of this decision. I have also considered the comments you have made in response to my colleague's 5.7 notice and will address these where appropriate. I consider the summary of the complaints made by my colleague in her notice is reasonable and are as follows. The firm did not make a legal aid application until May 2021, 6 weeks after Mr. Hussain instructed the firm. The firm only gave Mr. Hussain one choice of barrister, which he believes limited the representation of his case. Page 2 of 7. Legal Ombudsman. The firm and barrister only met with Mr. Hussain a couple of hours before his hearing on May 20th, 2021, which was an adequate time to prepare for the hearing. Mr. Hussain requested to speak to the firm and his barrister immediately after his hearing on May 20th, 2021, but they were unable to speak with him until the following week. The firm should have submitted a statement given by Mr. Hussain to the courts by June 17, 2021, but did not do this. The firm told Mr. Hussein on June 18, 2021, that they had consulted with the barrister privately and intended to apply regarding his litigation capacity without discussing this with him first. The firm and barrister only met with Mr. Hussein very briefly before his hearing on July 5, 2021, which was inadequate time to prepare for the hearing. The firm told Mr. Hussein they were not aware that an application to vaccinate his mother had been drafted on August 5, 2021, and ordered on August 16. The firm did not respond to Mr. Hussein's request to speak over the phone between July 22, 2021 and September 2 to discuss advice regarding his case and the vaccination order. The firm submitted evidence to the capacity assessor after the court-ordered date in September. The firm told Mr. Hussein that he could contact the litigation capacity assessor to challenge his findings, but did not inform him this would be used as evidence for the assessment. The firm did not share the transcript for the hearing on October 1, 2021, despite Mr. Hussein requesting these so he could raise an appeal. The firm communicated with third parties regarding Mr. Hussein's case, despite him asking them not to. The firm would not share details of Mr. Hussein's mother's solicitor or other third-party contacts with Mr. Hussein when he requested these. The firm did not make Mr. Hussein aware that there was a hearing on January 2022 and what they intended to discuss. The firm did not respond to Mr. Hussein's telephone calls and messages he left with reception between the start of October to December 8, 2021. The firm did not share any cost information with Mr. Hussein and did not give him any final cost invoices. The firm did not inform Mr. Hussein that there was a court order issued in March 2022 to conclude his case and did not share this information with him until June 2022. Mr. Hussein asked the firm in March 2022 why the hearing from October 1, 2021 was not published in the news as he expected, and they did not respond until June 2022. Mr. Hussein asked the firm to provide a written response regarding his question about why his mother lacked litigation advice, but the firm did not do this. The legal ombudsman is authorized to investigate complaints about the service provided by an authorized person subject to the remit of our scheme rules. Page 3 of 7. Legal ombudsman. An ombudsman will determine a complaint by reference to what is, in his/her opinion, fair and reasonable in all the circumstances of the case. In determining what is fair and reasonable, the ombudsman will take into account, but is not bound by, what decision a court might make, the relevant approved regulator's rules of conduct at the time of the act/omission, and what the ombudsman considers to have been good practice at the time of the act/omission. In addition to complaints about the firm, I understand that you have also complained to the legal aid agency and have raised issues concerning the firm's professional conduct. I also note that you have strong views about the actions of the agencies involved with the care of your mother. I note from the comments made to the investigator that you are of the opinion that our process is limited as to what may be achieved by way of a resolution. You also disagree with how we conduct our investigations. In particular, that we cannot investigate the firm's professional conduct. Further, from the engagement you have already had with the investigator and the comments you have made that you do not agree with the limit of our jurisdiction, our process for investigating complaints about service or the limitations of what this organization can investigate and the evidence that would be required to determine the issues. I note that remedies sought, including the level of compensation, exceeds that which this organization can direct. In terms of our process, your comments are noted. I would explain that the service we provide is governed by legislation, in particular, the Legal Services Act 2007. Our investigation process is conducted in all cases in accordance with the provision of our scheme rules. I would confirm that this organization does not have jurisdiction to determine or investigate issues in relation to the actions of third parties such as the local authority and/or social services. The provision of legal aid and matters relating to legal aid funding would be determined by the legal aid agency. Matters of professional conduct, which are for the firm's regulator, the solicitor's regulation authority. Allegations of criminal conduct. The decision made by the court or other agency, and page 4 of 7. Legal Ombudsman. Further, we have no authority to overturn or vary the terms of a court order. My decision is that your case should be dismissed under 5.7a, because it does not have any reasonable prospects of success, and 5.7n. There are other compelling reasons why it is inappropriate for the issue to be dealt with by the legal ombudsman. Based on your comments, emails, and views about the connected issues with the various agencies and the seriousness of the allegations made in relation to the loss of your mother, I consider that this organization is unable to provide the service or the outcome you require, because the issues taken as a whole would require determination of legal issues, regulatory matters, and allegations of serious criminal conduct, which are not within the remit of the service we provide or our jurisdiction. You have also indicated to the investigator that one of the reasons for using our service is in part for evidence gathering and fact-finding exercise. In particular, you are seeking disclosure of documents from the firm. You have said that you intend to use the information in subsequent professional negligence proceedings against the firm. I note that you have made a subject access request to the firm which has been declined, and that decision upheld by the Information Commissioner's Office. In your comments in response to the 5.7 notice, you have expressed your frustration that we have not pursued the firm for documents and evidence at this stage. I would explain the service we provide in the determination of service complaints is a free service. It is unreasonable and inappropriate that our process is used as a forerunner to a pre-action protocol for a professional negligence claim. We are an independent and impartial organization, and should you wish to obtain specific documents for such a claim, then the correct course of action would be to use the appropriate pre-action protocol, and if appropriate, to make an application for pre-action disclosure. I consider that the use of our service as an alternative to the correct pre-action protocol and as a fishing exercise is inappropriate. Furthermore, it is not the correct forum in which to obtain information from the firm where such a request has already been declined. For this reason, I also consider dismissal of your complaint under 5.7n is appropriate. You have said that you wanted us to investigate your complaint and find not just that the firm's service was poor, but that they were part of a conspiracy with the courts and local authority, and they sabotaged your case. In your response, you have said that you believe your mother was murdered. You have also indicated that you are seeking an investigation into wider issues involving third parties. You have the right to consider your options for redress against the firm, and I note your intention to take matters further both in terms of the nature of all of the issues. Page 5 of 7. Legal Ombudsman. And allegations of conspiracy and corruption, and seek a number of actions by way of remedy and considerable compensation for damages. I have also decided to dismiss your complaint under 5.7a, as having no reasonable prospects of being able to either determine some of the issues raised or direct the remedies sought. This organization cannot investigate allegations of corruption, conspiracy, or murder, and I would inform you that such serious allegations are not within our jurisdiction. They would be matters of professional conduct for the firm's regulator, and the criminal allegations would be for other agencies, such as the police, to consider. The investigator has summarized 20 complaints as to how the firm have shared information with you, but these complaints may not necessarily show the firm's service was poor. In her letter dated May 3rd, she set out the standards that would be used to determine whether the service was reasonable and the evidence that she would require. She has correctly informed you that the firm's service would not be found to be poor. It is instead the case that they have simply not met your expectations. Our investigations are evidence-based, and Rule 5.26 states that an ombudsman may require a party to produce any information or document that the ombudsman considers necessary for the determination of a complaint. I consider the evidence requests made by the investigator is reasonable and necessary for the fair and reasonable determination of your complaint. I note that you have said that you cannot provide the evidence in the format requested and have asked that a YouTube channel be viewed in this instance. Your comments are noted. However, evidence from a YouTube channel is not evidence that we have requested. The investigator has indicated that in the absence of the documentary evidence she has requested, then it is likely that a finding that the firm's service was reasonable would be the outcome in this case. I am of the opinion that a reasonable investigation cannot be undertaken without your engagement in our process or willingness to provide the information requested. For the reasons stated, I have decided to dismiss the complaint under 5.7a and n of our scheme rules. Accordingly, the case will now be closed and no further action taken. I confirm that this is a final decision and is the end of our process, and there is no further internal review. Page 6 of 7. Legal Ombudsman. This organization will not normally consider reopening a complaint that has been dismissed unless the circumstances are exceptional. Yours sincerely, Amanda Charlton, Ombudsman. Legal Ombudsman, www.legalombudsman.org.uk. Page 7 of 7.